I think we can start. Hello, everybody. The topic of this panel is the rise of antitrust enforcement in labor markets. I want to thank Paul and Lear for inviting us and organizing this wonderful event. I say we can jump into the topic. I will say a few words and then leave the floor to our distinguished speakers. I will start by saying that when preparing for this panel, I actually discovered, I didn't know, that initially, meaning shortly after the adoption of the Sherman Act, the relationship between labor and antitrust was one of hostility, because I learned that actually the first 12 prosecution under the Sherman Act targeted labor unions. Then obviously, as we know, US Congress intervened, and in 1914, with the Clayton Act, exempted labor organizing from antitrust enforcement. From that point on, the relationship between antitrust law and the welfare of workers have been largely one of indifference. While I think the antitrust statutes and economic theory provide a strong basis for using antitrust enforcement to promote more competitive labor markets in the interest of workers, both the courts and the antitrust authorities have traditionally paid little attention to potential antitrust violation in labor markets. But this has radically changed, at least in the US, I would say, over the last 10 to 20 years. If you want to identify a sort of turning point, I would say that probably that would be the case that was brought by the DOJ back in 2010 against Google, Apple, and a few other top Silicon Valley tech firms for agreeing not to solicit each other's software engineers. The case ended with a settlement, and then the defendants agreed in a full-on class action to pay the victims more than $400 million. The collusion was fairly blatant and occurred at the instigation of the company's CEO, like people like Steve Jobs and the likes. Probably if the conspirator had fixed prices in a downstream market, in the US, they would have gone to jail. But presumably because of the then unusual nature of labor-side collusion, the penalty was really only a commitment not to collude again in the future. But in that case, the DOJ said a few very clear things. First, it said that there was no basis for distinguishing allocation agreements based on whether they involved input or output markets. And it is because anti-competitive agreements in both input and output markets still create allocative inefficiencies. And indeed, in that specific case, the DOJ argued that the no-poaching agreement, that's how you call them, the no-poaching agreement at issue eliminated a significant form of competition to attract high-tech employees and substantially diminished competition to the detriment of those employees who were deprived of competitive important information and access to better job opportunities. Since then, and we will hear from Mark Woodward much more about this, the promotion of competition in labor markets has become a clear priority for both the Federal Trade Commission and the DOJ, and with respect to both conduct investigation and more recently also merger review. On the merger review front, I would simply say that obviously the starting point is that while antitrust enforcement have traditionally paid much less attention to the firm's power as buyers rather than as sellers, and have been particularly hesitant to check their power as buyers of labor, textbook economics shows that exactly like market power in downstream markets, which allow firms to charge a higher price for their goods or services, buyer power in labor markets allow firms to push wages below the level workers would receive in a competitive job market. So to date, and to the best of my knowledge, I don't think that there was no agency in the world that's ever blocked a transaction based primarily on the impact of the transaction on labor markets. But also this may soon no longer be true because in the US, the DOJ has sued to block the proposed merger between Penguin Random House and Simon & Schuster, which are two of the big 5 publishers in the US. And the theory there is that the merger will eliminate head-to-head competition between the two publishers for authors, specifically best-selling authors, who are the one who obviously needs a large publisher. And so, and the DOJ says in its complaint that this would make it harder for authors to earn a living by writing books, which would in turn lead to a reduction in the quantity and the variety of books published. So there's also an effect on the downstream markets. And the FTC also, parallel to the DOJ complaint, the FTC also has indicated that it intends to also consider a transaction impact on the relevant labor markets when reviewing a merger. So even if the DOJ were to lose, because the trial took place in August, and I think the parties are waiting for a decision by the judge, but even if the DOJ were to lose, the Penguin Simon & Schuster complaint shows that US agencies are now prepared to block a transaction based on concerns over excessive buyer power or concentration in labor markets. And I will stop here as an introduction. So as I said, we have a very distinguished panel of speakers today. I will start with Maria Teresa Maggiolino, who is a professor at Bocconi University, where among other things she teaches comparative antitrust law and data law and data-driven innovation law. And Maria Teresa will provide us with a sort of conceptual economic framework for antitrust enforcement in labor markets. Maria Teresa, the floor is yours.
Okay, thank you very much. Let me first say thank you to Paolo, Lear, and Pietro for inviting me. Very interesting topics, and so I'm very happy to share with you my ideas about the application of antitrust law in labor markets. I'm going to share with you right now, if it works. I hope so. Can you see them?
Yes, I think.
Okay.
Right.
So, as Pietro was saying, I would like to start from the economics of the application of antitrust law in labor markets. Why? Because, as I said, for many years, antitrust agencies and authorities around the world did not apply antitrust law in labor markets. So, somebody may wonder if they did so because of some kind of pitfall of antitrust law. One could wonder whether antitrust law is not so good at protecting workers or labor markets. Actually, it is not. To be clear, antitrust law can be applied in input markets, such as labor markets, as it is applied in output markets. If you look at this scheme, you can easily realize that when one firm has hold a lot of buyer power, or when a couple of more than two firms together hold a lot of buyer power, they can drive the market toward a worse equilibrium, an equilibrium which is worse than the equilibrium that we would have had in a competitive market. And how do they do that? By decreasing the demand for work, the labor demand, and by decreasing the wage and pushing it below the competitive level. So when they do that, when they exercise their buyer power to obtain these results, what do? They produce an inefficiency, and they produce a wealth transfer from workers to entrepreneurs. As it happens in output markets, when you see the markets moving from a competitive equilibrium to a worse equilibrium, when you see that weight loss and a transfer of wealth. So even traditional antitrust, and with traditional antitrust I mean antitrust law that protects efficiency and innovation, can find application in labor markets as long as the conduct we study results from the use of buyer power by one or more firms. In addition, economics, or better, labor economists that have focused their studies on labor markets, have shown that any reduction in the demand of labor may drive to a reduction in output. How does it happen? Well, if the output market is perfectly competitive, actually the reduction in the demand for labor does not produce any significant impact in the output market. But if the output market is not perfectly competitive, as it could be, And the reduction in labor, ceteris paribus, entails a reduction in output. And so, as it happens in every output market, when you reduce the quantity of the products and services available, it leads to an increase in price. So even if you were among those who believe that antitrust law should be applied only to output markets, and are not among those scholars, you could argue that inefficiency in labor markets causes, in the great majority of cases, when output markets are not perfectly competitive, causes a decrease in efficiency also in labor markets, in output markets. I know this is kind of counterintuitive, but there is a solid literature, economic literature showing that. So, what are my first two conclusions? That I know that right now in the world there is a big, lively debate about
Maria Teresa, sorry for interrupting. Maybe could you try to talk closer to the mic, because not sure it goes a little bit on and off, your voice.
Okay.
Thank you.
Can you hear me now?
Yes.
Can you hear me? Okay. Okay.
We heard you all the way, but a varying degree of quality.
I apologize for this. I apologize. So what I would like to underscore is that I know that right now there is a big debate about goals of antitrust law. And I know that there are many distinguished scholars that maintain that antitrust law should have the protection of workers among its goals. It's an interesting debate. I do not side with that vision. But what I can say is that even traditional antitrust law can do a lot to protect workers if we are interested in protecting them, as I am, by applying the traditional rules and by protecting efficiency and innovation. Because applying traditional antitrust law is enough to prevent firms' practices that are capable to reduce labor and decrease wages. In particular, you can work in parallel. You can consider output and input markets, such as labor markets, and you can find the counterpart of each traditional, let's say, anti-competitive conduct also in input markets. So the equivalent of price fixing is wage fixing. The equivalent of market division are no poaching agreements, and so on. You can even prosecute a firm, an employer in this case, for abusing its buying power by applying excessively low wages or by making exclusionary conduct at the detriment of workers and the well functioning of the market. So, a few clarification and a few open issues then. The clarification are that I know that there is a big debate, or well, more than a debate, that many people are very focused on consumer welfare standard and the protection of competition in output markets, but still we can apply antitrust law in input markets to make them or to take them being efficient and competitive. And obviously, in order to do that, and this is especially for EU lawyers, EU competition law lawyers, in order to do that, we must remember that employees and employers cannot be not part of the same single unit, economic unit, when we look at labor markets. They are when we look at markets where they produce and sell products and services to third parties. They belong to the same economic unit, they are the same undertaking, but actually we must consider them as belonging to two different entities, otherwise we won't be able to apply antitrust law. But then there are a few open issues. The first one should be, especially for economists, it's difficult to define the relevant labor market because it's difficult to put a limit to workers' ability to switch from one work to another. toward workers switch in order to escape from an abuse of buyer power. So how broad can be a job market? The economic analysis on this matter is not very sophisticated, even economists admit. Second, and maybe this could be even more interesting if we think beyond the boundaries of antitrust law and we focus on mergers, but still, even within pure antitrust law, there may be cases when you can conceptualize a sort of conflict between the protection of efficiency in labor markets and the protection of efficiency in output markets. Think to no competition agreements that are meant to reduce, that are meant to announce brand competition in output markets. You can achieve that result of increasing inter-brand competition in output markets by limiting workers' mobility via vertical non-competition agreements. But that limit to workers' mobility in the labor market causes a loss of efficiency. So on the one hand, you have an increase in efficiency in the output market. On the other hand, you have a loss of efficiency in labor markets. Maybe it's a bit simplistic, but from a theoretical point of view, you can conceive of such a situation. And so probably in this case, authorities and agencies, beyond analyzing the case, should also give us a kind of policy guideline to know which of the two efficiencies are more important to be protected. Thank you.
Thanks a lot, Maria Teresa, for very interesting speech you just gave us. Before moving to Mark, probably have one question. You basically, in a way, already answered in your presentation, but maybe it's worth spending another minute on this. So we know that certain commentators have wondered whether antitrust enforcement in labor markets is actually consistent with consumer welfare standard, which, although somewhat in crisis, still is the main standard underpinning modern antitrust enforcement, or if whether antitrust enforcement in labor market is actually promoting a different goal. And I think this doubt derives from a sort of apparent syllogism, which we know is not entirely true, the idea being that if firms use buyer power in labor markets to reduce wages, they lower their cost. And so downstream customers, consumers would ultimately benefit as the lower cost should result sooner or later in lower prices for consumer. And this would be the reason why some advances doubts as whether antitrust enforcement is appropriate under the consumer welfare standard, or if we are not basically protecting workers as such, like we're protecting consumers. I think it's, I understand this debate is in a way moot because it revolves around certain ambiguity. But my question, so we know that it's not entirely true, but it is so because harms to workers should be equated to harm to consumers under the same consumer welfare standard, or because, as there are indications, in the medium term, a more competitive labor market upstream is not just good for workers, but also for consumers. And if it's the second one, is this because, as you said, a monopsonist does not pass on to consumers? Now the lower cost is monopsony power allows him to reach in the labor markets upstream, or because, for example, as the DOJ and the FTC argued in their joint guidance for human resources professional, and in a way also in the case I was mentioning before, the merger between Penguin and Simon & Schuster, a more competitive workforce will ultimately create more better goods for consumers going forward?
Okay, thank you very much for these many questions. Clearly, I do believe that more competitive markets, labor markets, produce in the long run better results also for consumers. Okay, this is true in the long run, in the medium run, but maybe in the long run we will all be dead. So still, I would conceptualize the combination of the consumer welfare standard and labor markets in a different way. When we say that we protect consumer welfare, we want to say that we protect efficiency, because consumer welfare dwindles down when you reduce output and you increase price. Okay. Now, when you reduce labor and you reduce wages, the variable that measure efficiency in the labor market dwindles as well. So applying the consumer welfare standard doesn't mean to protect a specific group of people, the ones that are called consumers. Means protecting efficiency, means protecting a certain level of output. And in labor markets, that certain level of output, of quantity, is labor. And then I come to the second intuition you got, or insight you got. When I reduce the amount of labor that I employ in my in my firm, in my enterprise, I reduce as well the amount of output that I'm capable to give back to the market. So the idea that I reduce cost is incomplete. I reduce costs because I reduce wages, but at the same time, I reduce the amount of resources that I will put in my productive process in order to produce products and services. And therefore, I will also reduce output in the labor market, in the output market, if I have power there. So as I told you in the third slide, I show you, a reduction in the demand of labor, ceteris paribus, if downstream you got some kind of power, market power then, drives to a reducing output. So this kind of clash between consumers and workers is the result of a misconception of how the labor market works together the output market.
You convinced me. We'll now move to Mark Woodward. Mark is a Deputy Assistant Director in the Bureau of Competition at the US Federal Trade Commission, where he focuses on non-merger enforcement work. And before that, Mark held a variety of other positions at the FTC, including Acting Deputy Director and Advisor to an FTC Commissioner. So Mark, who is in DC, so thank you, Mark, for making yourself available at this early time in the morning. Mark will provide us with an overview of the enforcement action developments in the US with respect to both conduct investigation and merger review, as well as with insight on the empirical evidence and the policy considerations that have induced the US Antitrust Agency to make the promotion of competition in labor market one of their current enforcement priorities. Mark, the floor is yours.
Thank you, Pietro, and thank you for inviting me to the conference. I hope you can hear me okay.
Yes.
Great. Again, thanks for inviting me. I'm sorry that I could not be in Rome with you, and I will just try to share my screen here. Sorry. There we go. Has that worked?
Yes.
Okay, thank you again. So I do need to start with the introductory slide and just stress that the views that I'm expressing today do not necessarily reflect the views of the Federal Trade Commission. I'll talk a little bit about cases brought by colleagues at the Department of Justice, and I don't represent their views either. I'm only speaking in my personal capacity. So Pietro has already touched on sort of the history of the antitrust laws in the US. Most of these are probably familiar to the audience, certainly the Sherman Act, including Section 1, and we'll circle back to that, the Clayton Act, which is used in merger control in particular. But I just wanted to stress briefly Section 5 of the FTC Act, which prohibits unfair methods of competition. This was passed in 1914 at the same time as the Clayton Act, and Pietro has already mentioned that the Clayton Act and the FTC Act were passed for a reason, which was the Sherman Act got off just sort of on the wrong foot in the court system in the US, and the Congress said, we need to turn and do something different. FTC Chair Khan just gave a speech last week stressing that application and enforcement of Section 5 of the FTC Act is a top priority at the FTC, and stressing that the prohibition on unfair methods of competition is something different and broader than the prohibitions reached by the Sherman Act. And that may come into play when we talk about non-compete agreements that employees might be required to enter with their employers. So the vertical non-compete agreements that Maria Teresa addressed earlier, and we'll talk a bit about that later. So as Pietro mentioned, the application of the antitrust laws in labor markets does seem to be a high priority of the US antitrust agencies at the moment. The leadership of both agencies at the Federal Trade Commission and the Department of Justice have been quite clear about that. And why? Why is it a clear priority? Well, I would say because of the evidence that's come out about the effects of labor market concentration on labor markets and on workers, including on wages. This slide has a collection of studies. There are many more, but they tend to show that increased concentration is associated with decreased wages, with increased labor market power. And one study in particular that has gotten a lot of attention in the US studied the evidence from hospital mergers in particular and the impact on wages. That's the Prager and Schmidt article here, and found that, again, consolidation mergers were associated with a decrease in wages for healthcare workers. And then the last one on the slide here by Evan Starr is he's done a lot of research on the effect of non-compete agreements between employees and their employers, essentially stating that the employee may not work for a competitor after leaving the firm for some period of time, and has found that the data shows there as well that those agreements are associated with lower wages. So really there's a growing body of evidence, I think, in the US, and I'm not as familiar with the European literature, but in the US, that consolidation, increased market power is associated with harms to workers, including lower wages and working conditions that are less favorable. So we'll start with a focus on recent non-merger cases. So Pietro has already described that the high-tech no-poach cases, cases brought by the Department of Justice in 2010 against Apple, Google, Intel, a number of firms in the high-tech industry, marked a turning point of sorts in that this was a series of cases focused on effects in labor markets. In particular, as Pietro said, the agreements were that each firm would not solicit the other's employees. They would not call, Apple would not call employees of Google, for example, to attempt to recruit them. And these were treated as civil cases. So the remedy was an order that the firms would not do it again. The second case on the slide here brought by the FTC was interesting. It involved two European firms, Swiss ski manufacturer and an Italian ski manufacturer. So these were leading manufacturers of skis and ski equipment. And to sell their skis, they hired professional skiers to endorse their skis. And the agreement started out as the companies agreeing that if a professional skier had endorsed the other company's skis, they would not solicit that professional skier to endorse their skis. And that agreement expanded into an agreement that the two firms would not solicit each other's employees. And so again, this was sort of a classic no poach agreement, and the FTC entered a settlement with both firms. The reach of the settlement was limited to the United States, to skiers in the United States, and to employees in the United States, but the principles were the same as the principles in the DOJ's high-tech employee cases, which is no poach agreements are harmful in labor markets and should end. I will just briefly touch on the wage fixing cases at the bottom. There's been a series of cases in both agencies addressing wage fixing, so just agreements among employers to pay their employees, cap the pay that employees receive. And I guess I'll note that the FTC brought such a case in the fashion industry way back in 1995. So not so recent. These ideas have been around, but in 1995, the FTC brought a case against leading fashion designers in New York who had agreed that they would cap the fees paid to models of their fashion designs. Again, it was a civil case, and the remedy was simply that the companies would not engage in this behavior going forward. Pietro has already noted another shift in the US in 2016 when the FTC and the DOJ put out guidance for human resource professionals focused on non-compete agreements, on exchanges of wage and salary information between competing firms. And the guidance was kind of a signal that this is important to the antitrust agencies, but also at the same time, the Department of Justice put out a notice that it intended to investigate no poach agreements and wage fixing agreements as criminal violations. And as Maria Teresa noted earlier, these are analogs in labor markets to price fixing agreements that have historically been criminal violations in the United States. So there's been, in very recent years, the last year or two, a series of criminal cases in the US focused on no poach agreements between competing firms and agreements to fix wages between competing firms. The headlines in the last year or so have been about a couple of acquittals. So these went to jury trials, and the jury concluded that the defendants were not guilty of criminal violations of the US antitrust law. But I don't think that's the end of the story, and not the whole story at all. Along the way, there have been several attempts by the defendants in these cases to just dismiss the cases, to say that these are not criminal violations of the antitrust laws. And courts have largely said, no, these are classic per se unlawful agreements, can be subject to criminal penalties. And that, is again quite a development. I think that the cases that have resulted in acquittals, I haven't followed them that closely, but my sense is that they have probably resulted in acquittals on particular facts of those cases, and the Justice Department has been fairly clear that it intends to continue to prosecute criminally inappropriate circumstances, hardcore agreements to fix wages or not to solicit employees of competing firms. Moving on to merger control, again, Pietro has already highlighted at least one of these cases. It's the Bertelsmann case on the slide, which is Penguin Random House and Simon & Schuster, the book publishing merger that's currently pending in the courts in the US. As Pietro mentioned, the primary focus of the case, and again, I only know what I've read about it publicly. I have no inside information on this case, but the primary focus is on effects on authors, author compensation, and in particular, compensation to authors of bestsellers, as Pietro said, books that involve advances of $250,000 or more. I guess one interesting thing in just looking at the briefing and following the case from afar, what does this labor case look like? To me, it looks a lot like a very traditional antitrust case, but just involving labor markets instead of output markets. There are competing economists testifying. There are disputes over whether the relevant market has been defined properly, disputes over the quality of the evidence at great length, hundreds of pages that anybody can read. The briefs are public. But the ground that it's being fought on, the principles that it's being fought on are seem very familiar to an antitrust lawyer. So how that case turns out remains to be seen. As Pietro mentioned, a decision is pending with the court. And then I'll just touch on the last case on the slide. This was a case brought by the FTC earlier this year involving a merger of two hospitals, competing hospitals in Rhode Island. The FTC filed the case, the merger was dropped. The case itself focused on harm in downstream consumer markets. So the overlap between the competing hospitals and the provision of hospital services. But as we can see from public concurring statements of FTC commissioners, there was also a debate at the commission over whether to separately allege harm to workers in labor markets. Two of the FTC commissioners said, yes, we should bring such a case. This is equally important. I'm summarizing. And two commissioners said, no, the evidence isn't sufficient. We should not bring the case. And on the 2-2 vote, a labor market count was not included in the case. But very interesting to note, all four FTC commissioners agreed that the application of the Clayton Act, of the antitrust laws, to labor markets was appropriate. And in the appropriate case, the FTC should absolutely bring cases that challenge labor monopsony. And so again, as Pietro said, it's a priority. I think there's a lot of attention on labor markets at the FTC certainly, and future cases, it remains to be seen whether the FTC will, like the DOJ, bring a case where the primary focus is harm in labor markets. Just my final slide here, I'll briefly touch on a couple of miscellaneous policy considerations. One is a potential rulemaking that the FTC may be engaging in. The commission has said it's looking closely at, focused on vertical non-compete agreements between employers and employees. This was a subject, one among many, of an executive order issued by President Biden over a year ago, focused on competition, and he encouraged the FTC to look at non-compete agreements and consider a rulemaking. The FTC is considering a rulemaking. Again, that's where Section 5 comes in. The authority of the FTC to engage in rulemaking is under the FTC Act, and it will be interesting to follow, if this rulemaking proceeds, whether the FTC relies on Section 5 and how it articulates its authority under Section 5 and the reach of Section 5, which again prohibits unfair methods of competition more broadly than just the Sherman Act. And then just last week, the FTC put out a policy statement on enforcement related to gig workers. The core things that it focused on were familiar topics that I've covered in prior slides, including wage fixing, coordination between employers on terms of employment, and consolidated markets and the effect of consolidated markets on workers. But there was a general theme in the statement that gig workers in particular in the gig economy are particularly vulnerable to market power and to increased market power from employers. And this could result in unfair or exploitative terms in employment contracts. So again, it's a policy statement. It's not an enforcement action, but it indicates, as Pietro said, that this remains a top priority at the FTC, and it will be interesting to see how this plays out in cases. I will stop there, I think, and turn it back to you, Pietro.
Thanks a lot, Mark. Very, very interesting for us here to know about all this very wide variety of interventions in various areas. Maybe one quick question for you before leaving the floor to Patrick. Well, I had one to which, in a way, you answered. So my question, obviously, my questions are on mergers simply because of impact on labor markets in merger is unheard of in Europe, basically, whereas we have, as Patrick will explain, a number of precedents on the conduct side. So that's probably the one that for us here is newer and that's more even more interesting. So the first question would be based on the obvious consideration that obviously antitrust enforcement, like the theory and the empirical evidence is much wider and stronger in impact in downstream output markets than in labor markets, whether internally in organizing the activities at the FTC or the DOJ, there would be this idea also for reason of efficiency to analyze a case first, looking at the impact on the downstream market. There is a problem there, stop there without going and looking at the labor markets, and then only look at the labor markets once the agency has come to the conclusion that there is no significant impact downstream. But the precedent you told me about the FTC basically is an answer in the sense that in the case it was split, but the idea is that when there will be a significant impact on labor markets, this will be prosecuted together with impact on the downstream output markets, I guess. So my other question is on market definition, which probably in the merger review context is even more important than in a conduct investigation. And my question would be, do you have the sense that a significant impact on labor markets is linked to job markets which include highly skilled, specialized workers? Are these markets more prone to antitrust enforcement? Simply because intuitively, the more specialized an employee is, the more concentrated probably the labor market for that employee should also be. So the more specialized a worker skills are, the fewer alternative employers it will have. So is it likely that we will see those markets first targeted rather than markets where less skilled workers are active?
It's certainly, I think it's been the case that many of the cases that have been, there haven't been many, but of the few cases that have been brought have involved markets with at least more skilled workers. And that includes nurses, engineers, where there might be, yes, somewhat less mobility. And I think the tools that are applied to labor monopsony cases more generally are, as I said earlier, seems to be the case in the Penguin Random House case. The tools are very similar to the tools that we apply in downstream markets. And so what we're looking at, and this is addressed in the existing US merger guidelines, which are currently under review, but what we're looking for is a small but significant non-transitory reduction in the price paid to employees rather than increase in the price of goods. And when we see that, we can define a labor market. You know, Maria Teresa could probably comment on this more intelligently than I, but it does strike me that in general that test may be more likely to be met where there's you know, less worker mobility because of the fewer alternative options that an employee might have for employment. But again, I think that remains to be seen. And the other thing I will say that is in other contexts, including the non-compete context, as I mentioned, there is a lot of concern about the power imbalance between workers who are low-wage workers and employers in concentrated industries. And I expect to see a tension there, again, maybe under the FTC Act in particular, even if sort of outside of some of these principles that I've just been talking about.
Thank you. Very, very clear. Yeah. So basically, the test for market definition would be reversed. Would be an hypothetical monopsony test rather than a hypothetical monopolist test. Yes. And
Precisely.
what is clear, and then I'm talking also to the audience. What is clear is that right now, companies merging and having to report the transaction to a U.S. agency are each time they now wonder very early in the process whether they may be competing head-to-head with each other for similarly skilled workers. And that's part now of a preliminary merger assessment. In the US, we see this every day. We now move to Patrick Hubert. Last but not least, Patrick is one of my partners in the Antitrust and Competition Group at Orrick. And before moving to private practice, Patrick has held a number of positions and roles in government, basically, including being the chief investigator and general counsel with the French Competition Authority. So Patrick will provide us with an overview of where we stand in Europe when it comes to antitrust and labor markets, both at the EU and the national levels, and probably also what are the main open questions and issues. Patrick, you have the floor.
Oh, okay. Okay.
I can do that if you want.
Or maybe it's easier for me. Yeah. So it's. Should I move or? Yes. You're all right, Peter. Well, in the meantime, I want to thank Lear, of course, for this nice opportunity and providing me with an official excuse to travel to Rome. Great. We have it. And then here. Okay, perfect. So I will. Doesn't seem to work.
Is that something we should do? I have to do it manually. Okay, go ahead.
Well, okay. Still, in the meantime, I want to cover what happens here in the European Union. Basically, I will say that here we are late when we compare to the United States. I think catching up, slowly, but catching up. Essentially on agreements between employers, so on the buying side of labor markets, but also some things are happening on the offer side of labor markets, agreements between workers. And as regards merger control, there are discussions, but nothing really spectacular for the moment. So first of all, horizontal agreements between employers. This was discussed already a long time ago in the Bosman case. Maybe all people like me will remember that. The Advocate General has argued, or that could be possible, but finally the case was not, didn't clarify the issue. What is happening now, or what's happened for a number of years, is a rather spectacular number of decisions by national competition authorities. Many of them are in the sports sector, basketball, motorcycles, rugby in the UK. We see that in Poland, in Lithuania, because in this sector, in this industry, they're, of course, hiring champions is a big issue. And it's not, of course, a surprise that the first cases happen in this sector. But I think we can also focus on some decisions which are in more traditional markets, like this Hungarian decision which regarded the consulting industry, or the French decision, floor covering. In this French decision, which I know better because I'm French, it was a kind of classical situation where you would find a lot of exchange of information between competitors. And among the information exchange between competitors, you had information about wages and bonuses. So, in general, we can say that these national competition authority cases deal with situations where non-poach or exchange of information about labor issues are part of broader agreements. We find very few self-standing cases only addressing labor market issues, which probably explains, I will go directly to that, why it is sometimes difficult to answer some questions. For instance, are those cases real cartels? Are they per object? Are they per effect? If we allude, for instance, to the floor covering decision by the French authority, it is a per object infringement, but there are many classical exchange of information between competitors. So does it mean that this exchange of information on the buyer side of the labor market would have been by itself a per object infringement, a hardcore cartel? It's maybe a little difficult to say now. At the European Commission level, we don't find many things. I think it was here in Italy before the Italian Antitrust Association that Margaret Vestager mentioned in a speech where she alluded to new kind of cartels, new trends about cartels. She alluded to non-poach or wage agreements as part of cartels, which apparently means that they would be treated by the European Commission as hardcore cartels. But for the moment, we have not yet seen any significant decision. I think the Commission turned around this question some years ago in this decision about the ISU, International Skating Union, where this sport association was forbidding skaters to participate to this organization's competition if they had participated before to competition not organized by this organization. This has something to do with labor market, we could be said, but for the moment we are still waiting for what the European Commission will have to say on that. And so finally, we have those different questions which are still open. Are those decisions defending the workers' interest by themselves or just the consumer interest? Because if you have an agreement about the labor market, you will maybe, as Maria Teresa explained, you will lower your input, and because you lower your input, you will also lower your output and then have a price increase. Or are competition authorities really wanting to protect the labor markets? I think this is still a rather open question for the moment. And we also need to have a court decision, to know better about that. As I said, the question on whether this is per object or per effect is probably still open, even if Margaret Vestager's speech, including non-poach, for instance, in the cartel area could be an indication, a very serious and important indication. Are these agreements open to leniency application? This is also an open question. So we have a number of questions here. But the field is moving, there are more and more cases, and according to rumors, one of those days we will have clear cases by the European Commission. Now, of course, if competition law applies to labor market, this raises a question on whether it should apply to agreements between workers. There is a very simple situation when workers are salaried, traditional employees, they are not undertakings, and so competition law doesn't apply. And we also know that when you have collective bargaining with workers' trade unions and employers' trade associations together. Since the Albany case decided by the European Court of Justice a long time ago, we know that this is outside competition law. But what happens if we have independent workers, which are undertakings, who agree together, for instance, to try to get higher, I will not say wages, but revenues. Maybe they shouldn't be called wages. And the Court of Justice already alluded to that, and recently the European Commission published draft guidelines for comments. They are not yet in force. And what we see is that, yes, for the European Commission, independent workers, workers of the gig economy are undertakings, and so submitted to competition law. And so their agreements, when they try to bargain with their users, their employers, between brackets, could be caught by competition law. And what the draft guidelines are trying to do is to offer some kind of safe harbor, basically saying when independent workers behave or are treated like traditional employees, they should benefit from a safe harbor. For instance, if we see that in the same sector we have independent workers working side by side with people who are salaried, who are employees, this is a clue, this is an indication that they are treated as if they were traditional workers. And so they should benefit from this safe harbor and being able to agree between themselves to prepare negotiations with their counterpart of the buying side of the labor market. And same thing if they are clearly dependent on their employers, again, between brackets. Then if we go out of this safe harbor, competition law will apply. Doesn't mean that agreements will be forbidden, but it will be maybe a little more complicated. And well, I invite you, if you are interested, to read these draft guidelines. It's, European Commission drafting, so a little long-winded. Cannot describe all that, but it's interesting. Then merger control. Sorry. Do we have an interest toward labor markets in Europe about merger control? All people like me remember this almost 35 years old first merger regulation, dating 89. In this regulation, there was a recital, number 13, which said, what is written here, that the Commission must take into account the fundamental objectives of economic and social cohesion. So people at that time had said, yeah, when you assess a merger, you have to include social preoccupations. But, well, this was a recital, it was not an article, it led nowhere, and it has disappeared in the current regulation. No. So we can say that for the moment, there is not much to say. Of course, there is, in some countries, we have this situation where once the competition authority has assessed a merger, government can have a say and can overturn or change the decision made by the competition authority, and generally on the basis of concerns which are not, strictly speaking, competition concerns. There is an example, for instance, in France, I quote it here, 4 years ago, the William Sorin case, where the French competition authority asked for remedies, and thought the merger was authorized with rather strict remedies, and those remedies which would have led to a reduction of the workforce. And the minister changed the decision, allowing the the buying party to keep some activities that were supposed to be dissolved under the remedies, and ask as a commitment the buying party to keep the workforce at a certain level. So, of course, this is interesting, but it is not really competition law addressing labor market issues. It's rather a government with a social aim in mind, doing something the competition authority has not done. So I don't think it's really part of our problem. So for the moment, I think we see some articles, we see some speeches like this one about what could happen in the future on merger control. I think you could find a very recent and interesting paper in the review Concurrence number 3 of this year, so it's a few months ago, written by the chief economist of the Belgian Competition Authority, treating the different aspects of the question. So what we know is that there are a number of questions. What will be market definition within labor markets? How do we define narrow market for very skilled people, for instance, or should we have a more broader market definition? How are oligopsonies treated under merger control? We know it's possible because, for instance, when we have in Europe merger between distributors, we know that the question of the impact of those mergers on suppliers is generally studied by the competition authority, so this is not a revolution. And also the efficiency question. I think this is the most interesting because traditionally reducing costs is the most classical of efficiencies. And one way to reduce costs when you merge is, of course, to reduce the workforce post-closing, post-merging. And so the question, I think, the radical, the revolutionary question would be, should we move from the current situation where if you have a problematic merger from a competition point of view, a traditional competition point of view with consumer welfare in mind, it is problematic, but fortunately there are efficiencies like reducing the workforce, so maybe it could be authorized. Admittedly, we know that efficiencies don't work very well with the Commission or National Competition Authority, but in theory, this is something that could happen. Should we move from that to the almost opposite situation, where we would have a pro-competitive merger, economically speaking, but it could be forbidden just because it will harm the upstream labor market? That would be a dramatic change, and for the moment I don't think we are seeing that, but maybe that's a question we could still ask ourselves in the future. And I think with that, I finished. But maybe you have some difficult question for me.
Thanks a lot, Patrick. Probably before opening to the floor, more than a question, I have a comment. So I see your point, whether there is not, it's not entirely clear whether like no poaching or wage fixing in Europe would be considered a by object or a by effort restriction. I frankly was convinced by what, and you mentioned it, Advocate General Lenz said back in the 90s in its conclusion on the Bosman case. Then the court obviously only ruled on the liberté d'établissement, but the Advocate General said that naked, no poaching or wage fixing. So agreements which are not connected to anything else, to a transaction or to which they could be ancillary, as such, should be treated as by object, like it is in the US, basically, violations of Article 101. And actually what I think was convincing is that if you read Article 101, letter C, you have a specific reference to allocation of sources of supply. So the point C said that market sharing or sharing of sources of supply, and a no poaching agreement is exactly an allocation of the supply of the workforce. So I think you're right. We don't have many cases. We don't have cases which analyze only no poaching. They're always in the context of a broader conduct. But should they be? I think that the analytical framework would probably be that one, actually. And by the way, if you look on the merger side, so the non-compete ancillary to transaction are ancillary to transaction. But if they are not, and it's a pure non-compete, it will be by object restriction. And so no poaching should be exactly the same on the other side, in my view. Now, then I find very interesting what you said on the issue of efficiency. I was thinking the same thing. So imagine a situation where, as a result of an efficiency, the merger will result in lower prices for customers, but rather than shrinking the workforce upstream, it would also determine an increase of buyer power in the labor markets, allowing the merged entity to reduce wages. Then what an enforcer should do, he should do a sort of very complex balancing exercise to see whether the efficiency downstream outweigh the negative impact upstream. And in any event, as you were saying, probably the lower cost deriving from the increased buyer power, which is the negative impact upstream, should not be considered an efficiency itself, because otherwise there will be a sort of double counting. But these are all things that complex, and probably we'll only know if ever a case like this will appear on our radar screen.
Maybe you could say that it's rather classical to analyze this kind of situation with traditional supply markets, because you can harm your suppliers in a merger, but nevertheless, it's not because the competition authorities would analyze the impact on suppliers that they will totally discard the fact that getting a better bargaining power on the upstream market is necessarily something you don't take into account. Yes, you take it into account up to a certain limit, given the harm you will maybe produce on the upstream market. So sophistication is probably ahead. Yes, I agree with you.
Okay, we'll now open it to the floor for questions. If you could identify yourself and tell us to whom the question is addressed.
Thank you. I don't know if this is... Good, thank you. Ana Sofia Rodriguez, I'm the chief economist from the Portuguese Competition Authority. And just to note that we have a decision, an infringement decision from last year of a naked no poach agreement in the football sector. So regarding football players, not only the stars, of course, the first and the second league were included in this agreement, and the Portuguese Football Association as well. My question to the panel, I would invite Patrick to answer, but any of the other panelists as well, is why would there be a reason that you could see for the treatment of an horizontal agreement in labor markets to be treated in a different way from an horizontal agreement in any other market vis-a-vis the upstream market? What I mean is we have decisional practice regarding buying cartels as a per se approach. You have the raw tobacco cases. So why would there be a reason to depart from that regarding labor markets? Thank you.
I can try a first answer, but maybe an economist would be better placed. No, I think you're right. It's normally the same thing. But firstly, we can observe that cartels on the buying side of the market are not very frequent. They are rare. For some reason, I don't know why, but it's a pure observation. And then, of course, on the labor market is also protected by a whole body of laws in our European countries. It's not a market totally identical to the others. And so it's also possible that you can treat differently markets where there is absolutely nothing else than competition law to protect the suppliers from markets where they are protected by a whole body of laws which are very complicated, specialized court, etc. It's not easy. And non-solicitation clauses, for instance, are also treated by labor tribunals or labor courts in many countries. So there is an overlap between the different fields of law, which could make the situation a little more complicated. But it's not a reason to exclude them, but it makes things maybe a little complicated.
Maria Teresa, Mark, first of all, could you hear the question loud and clear? Yes. you want to add something? Otherwise, I can say something. Personally, I agree with you. But I think you're talking about a very specific example, which is a pure job cartel, basically. So employers getting together and deciding on a no-poach, on a wage fixing, on some kind of restriction, and that's it, without this being linked to anything else. In that case, I agree with you. I do not see any reason for why we would need to distinguish, all the less in Europe, because in Europe we also have this, I know it's not completely decisive, but we also have a very clear also a reference to this in the statutes. And so I don't think there's any doubt that this should be treated as a per se. I also agree with Patrick in the sense that obviously things in practice can be much more complicated and nuanced, and so it remains to be seen whether this will also always be the case or not. But I think a naked no poaching, to be clear, on its own, it would be treated like per se by object violation. And again, this was clearly said by, that was the position that the Advocate General took in Bosman, very clearly, without any doubt.
I agree with you, Pietro, if I can
Sure.
jump in. I totally agree. Naked no poaching agreements are, for me, a restriction by object, but there may be cases, more complex ones, as Patrick was saying, where no poaching clauses come together with acquisitions, mergers, and in those cases, there could be the case where the no poach clause is an ancillary restriction to the. It's necessary, strictly necessary to allow the acquisition or the joint venture. So there may be cases where, as it happens in output markets, where you have price fixing that may be an ancillary restraint. There may be cases where no poaching is an ancillary restraint.
I agree. That's exactly my point. I agree. Any other question?
My name is Neyza Ünebol. I am a competition lawyer practicing in Turkey. And my question is to Patrick and Mark. I want to ask you to elaborate more on your view for non-poach agreements in the context of a franchise agreement. I would want to know whether you would distinguish franchise agreements, non-poach clauses, in terms of object or effect restriction, and whether you see any difference in the approaches adopted in the US or in the EU jurisdiction.
I would start with Mark, because probably there are a few cases.
Sure, I can start, and this has been addressed in some cases. Several state, local attorneys general have addressed non-compete agreements by franchisees in the franchise context, and there've been some cases, not many, and it has been a subject of debate. Clearly, there are differences of application in the franchise context. I think the position of the current administration, though, has been to focus on the nature of the agreement, which is, again, between the employee and the employer, a straight non-compete agreement, and the effect of that agreement on labor mobility and the ability of the employee to find better wages, better working conditions. I think, again, often these agreements are in contexts where there's a significant power imbalance between the employee in the low wage sector and the employer. So I think the current administration's position has been these can be condemned per se, but there's frankly been a shift between the last administration in the U.S. in terms of how these will be analyzed, or how these should be analyzed. And like many of the things that we're talking about in the U.S., it remains to be seen how this will all play out in the court system in the long run.
In Europe, I am not aware, but maybe they exist, of any case involving employees of franchises. What we know that's more frequent is a question about non-compete clauses within franchise agreements, which limit the freedom of franchises to change, to leave a network and join another network. But that's more classical non-compete question, which is probably different from not really addressing labor market issues, but maybe it will happen one day.
More generally on franchising, it is interesting, right? Because franchising was something that I dealt with at the very beginning of my career, and then it was something of a forgotten argument under antitrust law. And now, on these and other aspects, we see a revival of application of the rules to franchising, including our own Italian Competition Authority, who, under completely different respect, is looking into a number of franchising networks. So things come back, as usual, in antitrust.
Okay, may I add something? Working with purely vertical franchising agreements, non-competition clauses, I would wonder about the efficiency justification for such a clause. Why are you preventing the employee from moving away? Probably, if you can find a justification, for example, if the employee has a kind of know-how, is a very sophisticated employee, that clause could find a justification, pro-competitive justification, I mean, in a purely vertical agreement. Otherwise, if you limit the mobility of non-specialized employees, I would find more difficult to find out a pro-competitive justification for such a behavior.
Maybe I can. The French cases I know about, yes, are in this line. They are not per object cases. And so they deal with the duration of the non-compete clause, the distance between the first shop and the new shop, etc. So they balance different interests. Yeah.
Indeed, indeed.
So yes, so Maria, what you're saying is that in an event, in a vertical scenario, you should consider the existence of any possible justification, which would obviously make it somewhat by effect.
Yeah. To be clear,
unless clearly on its face there could be no possible reasons, which could be the case, for example, of very low-skilled workers, something that, and in that case, you may want to pursue a sort of by-object approach.
One thing
Makes
is
sense.
blocking someone who fries the chips, and one thing is blocking somebody who is, I don't know, the manager of your, how you say, of your shop, who has a very specific skill about your softwares and the way in which they work and things like that.
Agree.
Yeah, I agree. This has been a focus in the U.S. as well. I have not personally heard a good efficiency justification for the non-compete agreements with, yes, the fast food worker cooking the hamburgers.
Any other question? I think we can take one more probably, and then we'll all go to lunch. So we'll all go to lunch. Thank you very much. Thank you. And thank you.